Court will note the appearance of Ms. McNiff on behalf of plaintiff, Mr. Zoglio on behalf of the defendant. This matter is before the court on the defendant's objection to the 7-day order submitted by the plaintiff in this matter. I've read the pleadings. Anything else, Mr. Zoglio, before we proceed?
Just briefly, Your Honor, and I certainly don't want to take up too much of the court's time this morning. It appears there's really 3 items. And the one item I think has been resolved. The child's age 4 and not 5, and that should be corrected. And I don't believe Ms. McNiff is opposed to that. The other 2 items are when I was looking at dealing with the summer parenting time, looking at the friend of the court policy, I had thought reading through that, the Calhoun County policy, that it appeared that the child is supposed to get, when the child's not of school age, the child's supposed to get an amount of weeks in the summer equal to the child's age. And since the child is 4, we were anticipating 4 weeks in the summer and not half of the summer, especially since the custodial environment is with the mother, as the court clearly stated. So that's one issue. The other issue is that the parties had a temporary agreement, and actually Ms. McNiff drafted this on the holiday parenting time, as outlined in my objection, specifically New Year's Day, Christmas Eve, and Christmas Day to be starting from 6 until 6 p.m. on the on the following pickup time. So that was a little confusing when I received that from counsel, because they already agreed on holiday parenting times. Despite some of the conflict in this case, Ms. McNiff and I have actually had a lot of conversations and had agreed on some language in temporary order. So I was surprised to see that. However, those are the 2 issues: the 4 weeks versus the half the summer, and the start of the holiday parenting time. Okay.
Ms. McNiff, I assume that obviously the times on the temporary order were obviously temporary, and you were simply, I guess, incorporating what we consider to be standard parenting time. Is that it?
Correct, Your Honor. I drafted the judgment in compliance with what the court ordered.
Okay. Well, Mr. Zoglio, you probably don't know, but there is no standard parenting time through the front of the court. However, there is some time frames under the Family Practice Committee parenting time schedule. I did not incorporate that, and I did not rule upon that in this particular matter. I ruled on kind of the traditional front of the court schedule. Otherwise, I would have specified the Family Practice Committee schedule. So the court does believe in this matter that Ms. McNiff's judgment does reflect the court's intention in this particular matter. So the court will order and enter that particular judgment. Okay. So thank you all. And Henderson on behalf of the plaintiff, Mr. Todd on behalf of the defendant. This matter is before the court on the defendant's motion to show cause and to hold plaintiff in contempt. Mr. Todd, I don't know if you've received the answer yet. Obviously, it does appear that plaintiff is disputing and contesting the allegations you make in your petition.
Your Honor, I have. I guess, to be honest, I think she's giving some reasons for denials of parenting time, but none of which actually make any sense, because she's alleging, in essence, that the child doesn't want to go, and she admits that there is new information, but that would only be able to come from the plaintiff providing that information to the child. I mean, the short and sweet of it is, their statement is indicating that we filed something that is not based off of fact, which is actually quite the opposite. It's evident that Mr. Franzman has been denied all of his parenting time since the past 2.5 weeks. And all of the allegations are at the very best hearsay. In fact, one of the responses indicates that it is the nephew's twin sister's son. So literally they have absolutely no information. There's an allegation in essence that Mr. Franzman is drinking, which we wholeheartedly deny. But the short and sweet of it is that his parenting time is denied, is continuing to be denied. He is happy to continue to have a breathalyzer if the plaintiff pays for that. And we believe at this point that it would make sense to actually have both parties submit to drug testing. Ms. Fletcher has failed to file anything to modify custody or parenting time. So I think he's entitled to the parenting time. His parenting time is being denied. They have no facts supporting their position. I honestly believe it's relatively clear cut.
Okay, well, thankfully you do, the court doesn't. As I read the answer, it basically states that the child refuses to go to the parenting time. Obviously, that's if that's proven in the case, that's in fact not a denial by the plaintiff if the child refuses to go. So the court does believe that a evidentiary hearing is necessary, taking testimony in this matter. So the court will refer the matter to the referee for an evidentiary hearing, and you should get notice of that shortly and then proceed in that manner. So,
Your Honor, may I please ask a question?
okay.
In our response, we indicated that we would like the parties to participate in counseling with Meredessa Katz as they have done in the past. And Meredessa could involve the child as well. She's available this week to speak with parties and the child. I asked Mr. Todd about the possibility. It's my understanding his client does not oppose that. So the request from us to the court would be before any hearing is ordered, there needs to be counseling intervention to see what issues exist and how can counselor assist the child with those issues. So defendant could have his parenting time. My client has not denied it. So
Okay.
Your Honor, we're just asking for an interim order that would allow the parties to participate in that counseling, co-parenting, family counseling with Meredessa Katz.
Mr. Todd, are you and your client agreeable to counseling with Ms. Katz?
We have no objection to that. I guess if the court does want to do an evidentiary hearing, though, we would request that simply move forward, and then in the interim, they can do counseling.
Well, I'll leave that up to the referee. I don't know the referee's schedule in this matter. So if the court would order that the parties would participate in counseling with Ms. Katz, apparently they can get that in and do some of it starting this week. So that'd be great so that we can get that going as quick as possible and get some of it concluded before we have an evidentiary hearing. So
Thank you, Your Honor.
Ms. Henderson, I'd ask, I guess, that you would prepare that order and submit under 7-day and provide both of you would provide your client with the information on Ms. Katz so that they could get those scheduled and proceed.
Thank you, Your Honor. Is the expense of counseling to be split by the parties?
Yes, we'll have it
Okay.
divided.
Thank you.
Thank you.
Thank you.
Thank you.
Can you hear me now?
Yes. Cody, I am joining. Says he's joining.
Ooh.
Whoa, weird. Not good. Try that again.
Mr. Attorney Whitehead.
Yeah, and my camera's really weird. We're acting weird. Let me just plug it in real quick. Hold on.
The court will note the appearance of Mr. Whitehead on behalf of the plaintiff, Mr. Bland on behalf of defendant. This matter is before the court on the defendant's motion for custody, parenting time, support, and other relief. Mr. Bland.
Thank you, Your Honor. Basically, we're dealing with Zoe, who is 4 years old. Currently, these parties have a 50-50 parenting time relationship. Dad lives in Emmett Township, I believe. Mom lives in Oshtemo. Zoe will be 5 in February of 2024. So I don't believe a school district's been determined. So we're looking at Young 5 type programs for this fall. I believe she can start as a 4-year-old in what is essentially is a preschool program, and then it morphs into a Young 5 after she turns 5. Communication, I think it's fair to say, between mom and dad is virtually non-existent. When he has indicated to my client that he does not want to talk to her except if it's an emergency. So I think this is kind of a typical joint legal type of decision that the court is going to have to kind of step in and start helping these people. It doesn't mean necessarily parenting time's got to change. It may be more convenient if it does. But in any event, I think we need to start thinking about what the school district's going to be and where we're going to go from there. Mom has checked out one school district and some preschool programs. She does not want to run right up to the deadline. As the court is aware, certainly with everything going on, it takes a little bit of time to work this through this system. She believes Zoe needs to know what's going on and where she will be going. She needs some stability and some routine. Right now, she has 2 daycares, and that's working out fine. I think dad's got a daycare in his area, and mom's got one in hers, but that's not going to work out as we go down the road further. From our understanding, dad works second shift. He leaves around 3:30, gets home somewhere around midnight, and so forth. And although I know there's a lot of working parents, obviously there's some options here that I think would maximize the time the child's spending with the parent. My client certainly wanted me to relay that, she's making these extra sacrifices at this time. She's getting up at 4:25 to make sure she can get the child to daycare and get herself to work. So I'm not expecting the court would make a decision today. What I would ask the court respectfully is to move it to a referee hearing so that each side can present evidence. I should say one other thing. I do note the appearance of counsel. I know somebody sent stuff to my client by registered mail, which she got this morning. I have not seen it. So forgive me, Judge, I've not seen an answer. If Mr. White, I'm sure Mr. White did something. This is not me doubting, but I just haven't got it. And I don't know if it was mailed to my office or directly to my client, but I'll leave it at that, sir. Thank you.
Okay. Well, Mr. Whitehead, reviewing your answer, you basically state the school district issue is in dispute and needs to be addressed. Is that pretty accurate?
Yes, Your Honor. The other party's motion, though, went beyond the school district. She's asking for a change in custody, which would be a change in the established custodial environment if she were granted what she's asking for. There's not any changes of circumstances or proper cause alleged, including that she never mentioned anything about his schedule in her motion that would even raise to a preponderance of evidence, much less clear and convincing for a change of the 50-50. However, we do agree that there's proper cause to proceed forward only on the issue of school. Currently, if the school were in the father's district, it would be about 5 minutes from him, and I believe about 30 minutes from mom. If mom gained what she wished, then the school would not only not be in either of the parents' school districts, it would have to be a school of choice, but then it would be 40 some minutes from dad and 20 minutes from mom. But that issue is certainly not in agreement, but we would like to limit the evidence you're hearing to the issue of school, since they have not alleged anything that would rise to a material change of circumstances, which would meet their burden of proof.
Okay. As the court reviewed the pleadings in this matter, the court does believe that there has not been a basis for a change in custody. The petition doesn't sufficiently allege any proper cause or change in circumstances to meet the Ledvarka threshold. The court will refer the matter to the referee for a hearing, a Lombardo hearing as it relates to the school, and that will be the order of the court. Court will end this matter at 9:26 a.m. You're free to go. Have a good day.
Thank you very
Judge,
much.
do you need to prepare that order, sir, before we go?
Now, we'll do an order that will refer it to the referee. This matter is before the court on the plaintiff's motion to determine child born out of wedlock. Ms. Thomas, I guess I'll ask, has any DNA testing been done in this matter?
I'm sorry, my bad. It has not. I'm sorry. It has not been done. No.
Okay. Well, the court is going to order that before we proceed. Do you have cooperation from the alleged father in this matter, Ms. Thomas, or not?
We're not 100% sure. We believe so. Yes.
Okay. Well, what we'll do is, obviously you can proceed anyway. If court will order that the plaintiff, the child, and at least the defendant in this matter participate in DNA testing, that would determine and be able to exclude the defendant if in fact he is not the biological father. And if you can, if you believe you can get the cooperation of the alleged father, the court would appreciate the testing on him as well.
Okay. We will do that. No problem. Do you want me to just wait until we get that and the results, and then give your office a call to schedule the?
Yeah, get the results, and then we'll schedule for a Wednesday afternoon hearing.
Okay, perfect. Thank you.
Okay. Thank you. So that's Greenlee Floor on behalf of the plaintiff, Ms. Thomas on behalf of the defendant. This matter is before the court on the plaintiff's objection to the referee order in this matter and request for de novo hearing. Ms. Greenlee Floor, if you would obviously enlighten me as to what evidence you believe would be presented at an evidentiary hearing pursuant to Michigan Court Rule 3.215 parens F parens 2 in this matter if we proceed with an evidentiary hearing.
I don't think it's so much that new evidence would be presented so much as I think the referee may have misinterpreted the evidence that was already presented, and in fact is also reflected in his actual order itself, which found basically in favor of my client and more factors than the other client, and found my client's testimony to be more credible. However, didn't really award him any more parenting time. So we think that there's an error in the actual decision, although that the reasoning is correct, the decision is not correct. So we were requesting that the court review the decision and determine whether more parenting time should have been awarded.
Okay. Well, I did do that. So the court did review the referee opinion, the one dated in October of, well, the original order was 2019. And then subsequently the parties had two evidentiary hearings in this matter in 2020. In doing that, I note that the referee found that the father changed employment, which would show his disposition under factor B, and found that in favor of the father. As I review that, I would state that, again, I think that was an error on the referee's part, that, again, just his disposition doesn't necessarily outweigh evidence of the defendant's disposition just because he changes that. In fact, changed employment. Court will note that the referee did not conduct an in-camera preference investigation of the child. The child is 6 years old. The referee should have conducted it in camera, but I would find that that was harmless error, as it does not change the ruling in this matter, the court's ruling. The other one the court notes as well is that the factor L states that the father is now working through Battle Creek Public Schools, which allows him freedom to exercise his full parenting time. The mother had previously complained that he did not exercise all of his parenting time. And the court doesn't find that obviously this is a sufficient matter to be considered as another factor in this matter. And that the referee is now saying that now that the plaintiff can exercise his parenting time, that again, that he should have, that factor should favor him. The court doesn't find that to be appropriate in this matter. So the court would take issue with the factors found in favor of the plaintiff father in this matter. As a result, the court does believe that, again, the evidence presented and the referee ruling is proper, notwithstanding the error in the way that the referee got to that ruling. With that, Ms. Thomas, is there anything you would like to add?
Well, I guess a couple of things, Your Honor. First of all, in this entire case, this was a backdoor attempt to gain custody. What they asked for would have been enough parenting time to give them custody, but they didn't do that. In the beginning, Mr. Robertson did a motion regarding custody. Once Ms. Greenlee-Core was in, she did a supplemental motion and indicated that the only issues before the court were parenting time and child support. The problem is, though, even in that same document, they're asking for another day every week, and that would be then equal. So the entire thing has been a backdoor for Mr. Robertson to get custody. And when Mr. Courteau did not do that, they're asking for more, but the more they're asking for, once again, would be equal custody. The other thing that we do take exception with, and that is this court took testimony as to employment, as to incomes, as to related expenses of employment, as to the healthcare expenses, as to all of that by these parties under oath. And yet this, for whatever reason, the referee also ordered this to front of the court for an investigation. And as the court is aware of the policy, the court, the front of the court, when they're doing their investigations, do not consider if the party is not working up to their capability as far as income wise. If they left a job to change their child support, they don't even look at those things. So frankly, having a front of the court investigation is just going to end up back in court. The problem is that and why we take exception is because all of this was testified to in front of the referee, and the referee needs to do his job and set whatever child support is going to be, so that either it can be agreed upon, it can be objected against, whatever. But he has the information, and he pushed it out to front of the court, which I think is uniquely significant of the way that this matter was handled, quite frankly.
Okay, well, I don't know why the referee did that if he had all the evidence before him. I have no idea, but again, I'm not going to interfere with whatever the intention of the referee was to get that additional information. But as I stated, the court does not believe that the referee made an error as it relates to the issue of custody, parenting time, et cetera. So the court is going to affirm that particular ruling in this matter. And I guess court would ask Ms. Thomas that you would prepare an order in this matter denying the objection. And well, in fact, no, you don't need to. The court will have an order in the file already for that. So that will be the ruling of the court. We'll end this hearing at 9:37 a.m. Before the court on the plaintiff's motion for child care location and meeting location and communication through app close. Mr. Vanderhorst.
Thank you, Your Honor. Parties have one minor child, Zakari. An order regarding custody, parenting time, and child support and miscellaneous matters was entered with this court on or about September 6th of 2022. The parties are currently sharing joint physical, plaintiff has physical custody and the parties are sharing joint legal custody. Joint physical, joint legal custody.
Yes.
Defendant has parenting time on alternating weekends and week on, week off in the summer. Pursuant to the order entered, the parties are to agree on a child care provider that is equally distanced between the parties. The minor child currently attends ABC daycare since January of 2023. Plaintiff is in need of the court to order that the minor child remain at ABC daycare full-time because if the child does not remain at the daycare at least 40 hours a week, plaintiff will lose her DHS funding that pays for the daycare. Also, there are no other daycares near plaintiff that are accepting new children, so this is the only daycare that is available that is near plaintiff. Plaintiff is unable to cover the daycare costs if she had to pay out of pocket. Because plaintiff has majority of the parenting time that the child is used to the routine of tending the daycare, she is asking the court that the child remain at ABC Daycare 201.
Okay.
Due to the fact that the child has to remain full-time at ABC Daycare for plaintiff to continue to receive her support through DHS, she is asking to meet the defendant at the TA Travel Center located at 15874 Road, Battle Creek, Michigan, 49014. To meet him there at 5:30 to 6 a.m. in the morning when it is his time during the summer, so she can transport the child to the daycare, and then at the end of her shift, or if the defendant can come pick the child up from daycare during his summer parenting time, so the child can still remain there full time. Plaintiff is asking that all summertime parenting time exchanges take place at the TA Travel Center. Plaintiff is also having difficulty communicating with the defendant. The defendant will often refuse to communicate with the plaintiff. She would like all communication go through the parenting app close. So to sum it up, plaintiff is asking the court to order the child remain at ABC Daycare, meet at the TA Travel Center, and all communication go through app close. Thank you, Your Honor.
Court would note that it is now 9:41 a.m. The defendant has not appeared, nor has the defendant filed an answer based upon the allegations at the petition. And at this matter, the court will order that the child would continue at the ABC Academy, that the parties would meet at the TA Travel Center or Travel Truck Stop at 11 Mile Road. It would order that the parties would, again, communicate through the app close in this particular case. The only thing I would note, Mr. Vanderhorst, the court takes issue on, as you said, that the child would continue at ABC in the summer when the defendant has a child. Obviously, I guess I leave that up to the defendant. He can do what he wants when the child's in his care. So, but that otherwise that the child would be at the ABC Academy.
Okay.
And Mr. Vanderhorst, you can prepare that order and submit under 7-day notice of entry.
I will, Your Honor.
Thank you. Court will end this matter at 9. Intervening party in this matter or interested party. This matter is before the court on the third party's motion for genetic testing. Ms. Bowen, I note that is now 9:44 a.m. and again, the matter was set for 9 o'clock. Neither of the other parties has filed any pleadings nor appeared in this matter. So the court would grant your order in this matter, your motion, providing for genetic testing. Is there anything else that you need, Ms. Bowen?
No, Your Honor, I will submit that to you today under 7-day.
Okay, thank you. We'll close the matter at 9:44 a.m. Matter on the Miller case. The court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. Thomas on behalf of defendant. We have two matters: the plaintiff's notice for entry of order and the defendant's objection to the order. Obviously, maybe I don't know what the confusion is in this matter. It did appear that the court did rule, when we were in court previously, that the plaintiff would get her clothing, personal effects, items given by the family, as well as her jewelry in this matter, and that again, the items that the court did not address at that time nor address in the prior judgment would remain in the home. What's the confusion, Ms. McNiff?
Your Honor, I thought that the court had determined that because there was an appeal filed, that the court wasn't going to rule on any of the personal property. So it was simply confusion on my part, I believe.
No, the intent was to again, to clarify that particular point, and the Court of Appeals can do what they want with it. And the court does believe that Ms. Thomas's order is correct and accurate. So it would be the intent to enter that order at this particular time.
Okay.
Okay. I don't assume you'll object to that, Ms. Thomas.
No, absolutely not. But
Okay.
there is there's another whole matter before the court today, though. In addition to that one, there's the initial order based upon the order based upon the initial hearing on the first. So there were two motions for relief from the judgment. That was the second one. We also have the motion for relief from the first one before the court, and Ms. McNiff had noticed it.
Yeah, that had to do with the coverture, didn't it?
That was one of the items. Yes, that wasn't the only item.
We have a hearing on that on Wednesday, I believe.
Yes, we do. That's why the court didn't address it today. We can address that on Wednesday when we have more time and
Okay, well, I think there were, so anything else in that same order, we can address all of that Wednesday then?
yeah, we'll do it on Wednesday.
Okay, let me ask this question. Caitlin, is the Lakeview one, the smack. So now they're going to regionals, and she actually will be playing tennis for an all-day event at regionals on Wednesday. Is there any way we can move that so both mommy and dad could go to watch her play? I mean, she's gone through a lot with this hearing already, so.
I understand.
We should be able to find something.
Yeah, we will do that. We'll talk to both of your offices, and we'll try to move it to another Wednesday.
Okay.
It seems to work out well. Wednesdays are more of an open day for the court, so Wednesday afternoon, so.
We do have some openings other days.
Yeah, staff is just saying we do have some other opening Wednesdays, so we'll contact both your offices and see what you can work out.
Thank you for doing that.
Mr. Dick, on behalf of the defendant, this matter is before the court on the defendant's motion for temporary custody, parenting time support, and spousal support. Ms. McNiff, I guess I'll ask you, the house did sell closed, and has the money been received as well?
That's my understanding now.
Okay. Just for clarification, obviously, because we have some other issues here as far as spousal support, et cetera, what amount of money did the parties divide up? Because
That I don't know.
Your Honor, they both received about $32,000.
okay, Ms. McNiff, you can proceed with your motion.
Your Honor, the primary issue today really is custody and parenting time. And one of the major problems is that dad works nights. He works from 7 p.m. until 7:30 a.m. Monday through Thursday. And so he won't be available to supervise the minor child at night, and getting the child going in the morning and off to school may be difficult if dad works until 7:30 and doesn't return home until sometime after 7:30. So we're asking that mom be awarded primary physical custody, with dad having 3 weekends per month to allow mom to have at least 1 weekend with the minor child. We also don't have any issues with midweeks if dad can do a midweek before he goes to work. As far as the summer goes, that's kind of problematic as well, since dad won't be available at night. And we would like to keep the same schedule throughout the summer, with giving dad some time during the summer when he takes off work for a bona fide vacation. But the schedule is really the hang up with regard to parenting time and custody. We're asking the court to set child support pursuant to the child support formula. And finally, mom is asking for temporary spousal support. Dad makes approximately twice as much as mom, and she does have a shortfall each month of approximately $700.
Okay. Ms. Page, your response.
Your Honor, thank you. We're dealing with a 15-year-old. We're not dealing with an infant in this matter. These parties have separated since March of this year. Since that time, my client has had the minor child every Friday through Monday morning. And in addition to that, he only works till Thursday morning at 7:30. He only works Monday through Wednesday night. He has been requesting from mom that he have the minor child Thursday through Monday morning to have more of an equal parenting time arrangement, and she's not willing to comply. He has a place for the minor child to stay. He has his own room. He does have his parents who are available to watch the minor child overnight if he is at work. My client does believe that both parties have a good relationship with the minor child, and that a joint physical arrangement in this matter would be most appropriate. Just so this court is aware, we were supposed to have mediation this week. However, our mediation was set for June 13th because the the mediator had a conflict. So we are set for mediation on June 13th of this year. We believe, like is indicated, as a joint physical arrangement where my client could have every 1 week he could have Thursday to Monday morning, and 1 week he could have Friday to Monday morning for parenting time, just until at least mediation, until we can come up with a long-term plan. During the summer, I think it's appropriate for him to exercise week on, week off parenting time. I do believe, as I indicated, those 3 days that he is gone, his parents are able to stay overnight. He'd be available during the day for the minor child as appropriate. In regards to child support, last year, mom made $51,000, dad made $99,000, and I believe that we can run child support calculations regarding that. In regards to spousal support, I do not believe this is a spousal support matter. If this court has to have a hearing regarding the parties' budgets, which they haven't really heard my client's budget, which I can go through, my client has substantial needs that, in addition to paying child support, that will need to be taken into consideration for any spousal support matter. So I'd ask this court to deny the request for spousal support right now and set this matter for further hearing and or for mediation.
Okay, thank you. Well, what the court's going to do, this is a temporary order. The court will order temporarily the parties would share joint legal custody, and the defendant would have physical custody at this time, subject to the plaintiff's standard parenting time. On those alternating weekends, the court would run those from Thursday through Monday morning, and just have standards. So the standard will be the summer, the alternating weeks. The court will, however, order in this matter that the plaintiff would have proper supervision for the child on the nights that he is working. however that may be, if it's his parents or whoever. Court would order support pursuant to the guidelines in this matter. The court, again, does note that now that the defendant will be receiving child support, that she clearly would be able to meet her budget. And the court doesn't believe that spousal support is necessary at this time. Also, the court does note that there were a number of what the court believes to be unnecessary or inflated expenses. Just an example, the entertainment of $200, gifts $125, vacation of $500, as well as pet supplies. So as a result, the court will not order any spousal support at this particular time. Court would ask Ms. McNiff that you would prepare the order, submit under 7-day notice of entry. Court will end this matter at 9:56 a.m. On behalf of defendant. This matter is before the court on the plaintiff's two motions for mutual restraining order, conserving assets, as well as for exclusive use of the home. Mr. Vanderhorst, I wasn't sure based on your answer, are you disputing a mutual restraining order on preservation of assets?
No, Your Honor.
Okay.
Not disputing that.
Okay, court will so order that then if there's no dispute. Okay, Ms. Baisno, you may proceed on the other motion.
Your Honor, thank you. In regards to the motion for exclusive use of the home, Miss Lily White moved from the marital residence approximately 5 weeks ago. She's been to the home twice since that period of time to get some more of her personal property. The day after Easter, approximately, she moved, I'll say 95% of the personal property from the marital home. Even prior to those 5 weeks, Miss Lily White has not been staying at the marital home. She does work overnights. She doesn't even come home to sleep necessarily. She's either staying at her mother's house or some other unknown location. We do believe it's appropriate due to the hostility between these parties that exclusive use of the marital residence for my client should be granted. And again, my client's been responsible for paying the bills associated with the home. He would continue to do so during the pendency of this action, but we would ask that this court grant my client exclusive use of the marital residence.
Okay, thank you. Mr. Vanderhorst.
Your Honor, I dispute those facts. Some of them are true. Most of them are not. My client has really been forced out of the house, but a little bit of history in this case, as I laid out my answer, was the plaintiff husband was out of state for approximately 40 days, March 1 through about April 8, April 10 in Texas. My client was there at the home. This is a major asset of the parties. It's probably worth around $500,000. My client does have accommodations in Three Rivers. Her mother lives there in a 4-bedroom home, but I don't want to order that exclusive use without a parenting time order. We have summer coming up. There are 3 minor children in this case, 17, 12, and 11. My client.
Your Honor, there's no parenting time motion before the court, though, Attorney Vanderhorst, at the time.
I understand that. I understand there is not that done, but my client has every right to live in that house as your client does. The hostility was totally brought on by your client's behavior, and my client's being punished for that. If somebody wants to leave the marital home, he can leave the marital home. He can move somewhere, and the hostility can go with him. So, this is a situation where we really, I don't want an exclusive use order without a parenting time order. We're going to have mediation coming up in a couple of weeks with Mr. Brundage. We're going to exchange verified information, which we haven't even exchanged yet in this case, on what the bills are, et cetera. And so I think it's premature to have an order of exclusive use without some order of the children.
Okay.
Well, I don't want the kids held hostage, Your Honor.
Right. Court notes, I would note, as Ms. Baisno said, there is the issue of parenting time is not before the court. So the court can't address that unless the matter is properly presented to the court, which is the only thing we have before us is the motion for exclusive use. The court is going to, in this matter, the court going to award to the plaintiff exclusive possession of the property. Court will make him responsible for the mortgage, taxes, insurance, and utilities on the property during that particular time. And that will address all of the issues before the court. Mr. Vanderhorst, you want parenting time issue in, then bring a motion and we'll address it. Okay. Mr. Vanderhorst will end this matter. Mr. Umlauf, on behalf of the defendant. This matter is before the court on the plaintiff's motion for temporary custody, support parenting time, and to maintain the status quo. In this matter, I guess, in this, just to clarify, Mr. Umlauf, I think you've stated in your answer that there was no intent on behalf of the defendant to remove plaintiff from the health insurance. Is that correct?
Your Honor, at one point, my client did inquire about the possibility with her employer, but was told that she could not do so. And the reason she did that was because, as we outlined in our response to the motion, the plaintiff was no longer depositing his paycheck into the joint account, and she was having trouble keeping up with marital bills. And for that reason was trying to figure out what she could do to be able to keep up with the bills.
Okay, but he's currently on at this point, is that correct?
That is correct, Your Honor.
Okay, so, well, with that, the court will order at least that continues, and Mr. Vanderhorst, you can proceed with the rest of your motion.
Thank you, Your Honor. Parties have been married since May 2, 2015, have 2 boys, age 7, age 5. Parties separated on March 2, 2023. Plaintiff has moved to Fairwell, Michigan, which is about 2 hours away from the defendant. Since the party separation, defendant has only allowed plaintiff to spend limited amount of time with the children. Plaintiff has a very close and loving relationship and would like to spend much more time with the children. Plaintiff is requesting that the court order that the parties receive joint physical and joint legal custody of the minor children. Plaintiff is requesting that he receive the children every other weekend during the school year, and during the summer, he received the children during the week, and defendant received the children every other weekend, holidays pursuant to the Calhoun County Parenting Time Policy. The plaintiff is from Farley, Michigan, and his family lives near him. He does have an apartment with sleeping arrangements for the minor children. He would like majority of the parenting time in the summer so he can spend quality time with children and his family. Plaintiff is on probation for domestic violence. It was recently sentenced in April. He's on probation for 1 year and is currently on a mobile breathalyzer for 90 days. I believe he submits 3 times a day to the mobile breathalyzer. He is currently in counseling and has attended therapy for a year prior to be placed on probation for domestic violence. During his therapy and counseling, never was his mental health issues brought into consideration. The issues that plaintiff listed regarding the status quo mostly have been resolved. The health insurance issue, as you stated, he's going to remain on her insurance. Also, he's going to be getting on health insurance and may be effective as of now through his employer, and he has his own vehicle insurance. He still is locked out of the joint checking account, and he would have liked access to that account to see what's being paid out of that account. The defendant in her answer listed that plaintiff made the offer of $1,200 a month per child support, and also $1,285 in marital bills, as referenced in her answer. He does not have the money to pay this. This was amount to approximately $2,484. Also, she's requesting a lump sum. Plaintiff does not have the money to pay that right now, due to the fact that he has his own living arrangements and he has to come up with rent and food and everything else. So in defendant's monthly budget that was attached to her answer, he is willing to pay for some of the bills, but not all. Plaintiff has already transferred approximately $7,600 of debt into his name. He is willing to pay approximately $568 amount per month toward the debts and the marital bills. There's a list on there that he's willing to continue those monthly payments. Also, plaintiff has been contributing to the marital bills throughout the party separation. To sum it up, plaintiff is requesting the parties receive joint physical, joint legal custody of the minor children. He would like parenting time during school year every other weekend, and the parenting time in the summer. He would like the children during the week, with defendant having alternate weekends, and that he pay $568 toward the marital bills per month. Thank you, Your Honor.
Thank you. Mr. Umla?
Your Honor, firstly, as it relates to the issues of the minor children, my client does agree to joint legal custody, but requests primary physical. For one thing, the plaintiff is living over 2 hours away in a city that the children have never lived in. The sleeping arrangements described by plaintiff's counsel are actually the 2 children sleeping together in a pull-out couch in an apartment. More concerning is the plaintiff's pattern of domestic violence and excessive drinking during the marriage. He has called my client some vile profanities in the presence of the minor children, to the degree that they have asked him to stop. In September of 2019, he drunkenly pushed her after a concert in Detroit, which caused her to fall and break her tibia and tear her ACL and MCL. When she sought medical treatment, the doctor indicated that this is the type of injury typically suffered by football linebackers. In January of 2023, he became so intoxicated that he began berating and threatening my client. She called the police, but the police, when they arrived, did not arrest anyone, and the parties agreed to simply sleep in separate rooms for the evening. The police left believing that they had diffused the situation. On March 3rd, 2023, the plaintiff consumed 9 Bell's 2-hearted ales and attacked my client, leaving bruising on her arm. He took her cell phone when she tried to call for help and threw it across the yard. That is why he is currently on probation. Despite all of this, my client does recognize the importance of the children having their father in their lives, and for that reason, she proposes that he have parenting time on every other weekend with alternating holidays and half of the summer, rather than primary physical custody in the summer. The reason for that, among others, is my is the children have extracurricular activities that they plan to attend in the summertime, including a coding and gardening class that they would not be able to attend if they were living primarily with the plaintiff.
Okay.
Attached to our response to the motion was a spreadsheet my client created showing all of the marital bills that both parties had benefited from monthly. She did not include any bills relating to the marital home, like the mortgage, propane, and electric, because she realizes she is living in the home and the plaintiff is not receiving any benefit from that home at this point. She added up those marital bills and found that his half of those monthly marital bills, as outlined again in our spreadsheet, was $1,285.04 per month. She further requests that he do indeed pay the $1,200 that he initially offered to pay her in child support, making the total monthly amount $2,285.04. She requests that he begin paying that every month, beginning in the month of June. She further avers that he owes her this amount of money for the months of March, April, and this month. However, and again, in accordance with that attached spreadsheet, she factored in all of the money he deposited into the joint checking account during that time, and also factored in withdrawals that he took out of the joint checking account. And there is a difference showing of him owing her still $1,730.37. She requests that he make that one-time payment to her. The reason,
Mr. Umlauf, am I correct that you stated your client was agreeable to joint legal, or did I?
yes.
Okay, I just want to make sure.
Yep. The reason that she blocked him from the party's joint checking account was that in the aftermath of their separation, he was spending so much money that she was having difficulty keeping up with marital bills. Finally, I would note that in addition to the bills outlined in that chart, she also pays a mortgage, propane, electric, and trash associated with the marital home. And this amounts to $3,899 approximately per month. Her net income approximately per month is only $4,116, leaving behind only $217 to pay for necessities like groceries and gasoline. That's not feasible, which is why she is asking that he split those marital bills in that spreadsheet equally and pay her the $1,200 per month in child support. Thank you.
Okay, thank you. Well, what the court's going to do is the court will grant the parties joint legal custody. As they agree to that, the court will grant to the defendant physical custody. Court will grant standard parenting time to the plaintiff, which is alternating weekends, one half the summer. Support will be consistent with the child support formula and guidelines. The court at this point, the plaintiff has stated he is agreeable to contribute $568 to marital bills. The court will order that he do that. The court is not going to piecemeal divide up property nor bills in this matter, other than as agreed to by plaintiff. So the court will not order any additional payment on those bills at this time, but will reserve that out for subject for following or additional evidentiary hearings in this matter. The court will also order that the plaintiff would not consume any alcoholic beverages or any alcohol at all during the time that the children are in his care. So just to clarify, sir, if you are caught and found out that you are consuming alcohol at the time the children are with you, the court could, in fact, terminate all parenting time that you'll have. So I just want to make sure that you're aware of that. And
I understand.
okay. Mr. Vanderhorst, I'll ask that you would prepare that order and submit under 7-day notice of entry. Mr. Schaefer, on behalf of the plaintiff, this matter is before the court on the plaintiff's motion to enforce consent judgment and for contempt. In this matter, the court does note it is now 10:16 a.m. This matter was set for 9:30 a.m. The defendant has not appeared, nor has the defendant pled in this matter. As a result, the court will grant the requested relief, which would order that the property at 430 North Linden Street would be listed for sale within 7 days of today's date, that the court will place a lien against the proceeds from the sale of that property to pay off the mortgage on 126 Serby, as well as to pay off the child support arrearage. And the court would grant Mr. Schaefer your request for attorney fees and costs of $1,020, which would also be paid out of that the lien against the proceeds from the Linden Street property. With that, is there anything else, Mr. Schaefer?
Oh, I think that covered everything, Your Honor. Thank you. I'll prepare that order.
Okay, thank you. Court will end this matter on behalf of the plaintiff, Ms. Baisno, on behalf of the defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Huffman.
Thank you, Your Honor. I'll just address real quickly. So in this case, either There is an established custodial environment with both parties, as both parties cared equally for the children their whole lives from birth up until the parties separated in mid-January. This action was filed in April, mid-April, or I think beginning of April, actually April 9th, I believe. But as a temporary solution, so if there isn't a custodial environment, established custodial environment, then obviously there would be no custodial environment at all. We don't believe there is an established custodial environment with just mom, because there hasn't been enough time established. But in any event, as a temporary solution, we'd ask the court to start standard parenting time every other weekend, to start immediately, either this weekend or next weekend, with dad. And I don't think anything has been alleged or to make this court believe that Mr. Bombella is incapable of caring for his children, or that it wouldn't be in the children's best interest to be with their father at least that limited amount of time. So we'd ask the court for parenting time at least that amount, and we'd also ask for half of the summer to start sometime in June. So if we want to start with some every other weekends for a month, and then start in June, mid-June or whatever, for half of the summer, week on, week off, I think that would be a good idea. And then by the time we set or have our hearing or mediation, I think we could probably get this resolved by then. Thank you, Your Honor.
Okay, thank you. Ms. Pazon?
No, thank you, Your Honor. My client does believe it's in the best interest of these minor children for father to have supervised parenting time, as alleged in my answer. Dad works at Post, where he works third shift. He was working 12-hour shifts and has been for a period of time, where he has to request time off, including requesting time off for each weekend he would ask to have these children. And he's often forced to work a lot of overtime. When he took this position, he was very confident with my client that he'd be making a lot of money due to the fact of how much he would be working. In regards to the parenting time every other weekend, my client is objecting to that. She would prefer supervised parenting time with no overnights. We are told that he is living with Nicole Bibbins, who is his girlfriend, who has a history of drugs, drunk drivings, like driving my license suspended, and often evictions in the Calhoun County courts. And I believe this court could take judicial notice of those charges. The plaintiff in this matter also has a history of taking ecstasy, as well as bragging to my client that he wanted to start selling marijuana again, which raises major concerns for my client for these minor children who are only 3 to have unsupervised parenting time with their father. My client has been solely responsible for doctor's appointments, day-to-day routines, bedtime routines. The plaintiff in this matter has not seen the children since February 6th of this year, and he has not reached out, besides through attorneys on 2 occasions, to see the minor children during that period of time. My client was aware he had time off, and he didn't request parenting time during those periods of time as well. My client also has concerns in regards to him working third shift, being able to be awake during the day for these toddlers. He has a history of leaving his guns and knives out, which my client always had to clean up after him. In addition to that, these minor children are currently being tested for autism. They're going through evaluations. Their Dr. Ismail has recommended that the children stay in a consistent environment with their mother during this testing to make sure they can determine if there's true autism or not. So we're asking that this court enter an order for alternate weekends, Saturdays from 12 to 4, Sundays from 12 to 4, being supervised by a mutual agree upon supervisor, which would exclude his current girlfriend, and ask that this court enter an order regarding the same. Also, in regards to child support, it's believed that dad's earning approximately $90,000 a year. My client works for Verizon, where she works from home, and she makes $65,000 a year, and asks that child support be calculated using those figures as well.
Okay, thank you. Anything else, Ms. Huffman?
I would just state that my client is living alone in a 2-bedroom, 1-bath apartment. He lives on Michigan Avenue East. I have the address here, but he does live alone. As I stated, it's an appropriate 2-bedroom, 1-bath home. He stated to me that he is able to get every weekend off. He can stay awake. There's no issue with that. He's an adult. I don't understand why there would be a problem with him being able to stay awake during the day. Consistency with these children is going to include dad, period. That dad is going to be in these children's lives. That's just the end of the story. So consistency, the sooner we get that started, the better it'll be for the children. And I think that needs to start immediately. And we're fine with child support being whatever the numbers are. So if mom wants to, if Ms. Pazna wants to send over numbers, we can get that going. Whatever child support calculates to, we're fine with that.
Okay.
Thank you, Your Honor.
Okay, what the court's going to do in this matter, the court will grant temporary custody to the defendant mother, support pursuant to the guidelines. So court will order that the parties would exchange their income information within 7 days of today's date. And the court would grant to the plaintiff standard alternating weekend parenting time, one half the summer, and alternating holidays. The court will grant first holiday being the 4th of, well, it'll be Memorial Day. Memorial Day, the court will grant Memorial Day to the plaintiff and then alternate holidays thereafter. And court will order Ms. Huffman that you would prepare that order and submit it under 7-day notice of entry.
Thank you, Your Honor.
Your Honor, is this court going to comment about who the minor children will be left with, or does he have to be present during his parents' time that he's acknowledging that he can take those weekends off?
I'm not going to address that, Ms. Pace, no.
All right, thank you, Your Honor.
Okay, thank you. Court will end this matter at 10:30. Motion to revoke acknowledgement of paternity or parentage in this particular matter. I'll ask Mr. Dickinson, has a DNA testing been conducted in this matter?
No, it hasn't.
Okay. Well, what the court's going to do is the court will first order that the parties and the minor child would engage in DNA testing. And that, again, once the testing has been completed, then Mr. Dickinson, you can contact the court at that particular point, and then we will schedule it for further hearing, okay?
Okay.
Court will order at this particular time. Ms. Cohen, you acknowledge, I think the defendant stated in the petition that you had stated that he is not the father. Is that correct?
He could be, but he could not be, yes.
Okay, so we don't know. We do need the testing.
Correct.
Okay. Court will order that. You could, there are ways that you can get that done at little or no cost through the front of the court. If you contact them, that's possible, but I don't know if the case qualifies for that or not. I'm just mentioning it as a way that you could do it. Otherwise, the court would order that the parties would equally pay the cost of that testing. Court will end this matter on behalf of the court's office. This matter is before the court on the defendant's motion to set aside referee recommendation. The objection apparently goes to the fact that the defendant is paying, he's alleged he's paying the sum of $312 per month for medical, dental, and eye care, and that was not taken into consideration. The court has reviewed the support calculation, which confirms that there was no credit for medical insurance. Mr. Magnuson, are you disputing that at all?
Well, I don't know. I'd like to know more. If he has medical insurance that covers the child, certainly that should be factored in.
Okay.
Well, because I also got like a $15,000 bill. I don't know if the court can see that from all of when she was first born, she was put in the NICU, and so I got a $194,780.45 bill, and then by the time insurance and all the made up numbers they throw around, I owe $15,660.11 just in, that's why I've been working so many hours, because I've been trying to pay down all of her medical bills and stuff. I don't even really care about paying child support. For me, it's not even an issue. I'm going to take care of it no matter what. I'm more worried about it being over 40 hours.
Okay.
Because
okay. Well, court, what I'm going to do, sir, at this point, the court is going to order that you would provide to Mr. Magnuson proof that you're paying insurance, either through your paycheck stubs that would show that it's being deducted, et cetera. And after you provide that proof to him, the court will, in fact, order that the support would be recalculated, giving you credit for any medical, dental, or eye insurance. Okay.
I submitted all my paycheck and stuff with all my paperwork that I sent to the court. So I don't do I do it a different way, or
send it to the front of the court's office to the attention of Mr. Magnuson so that he gets that, because I don't know how it was submitted or not submitted previously. Okay. And again, if you do that and we got confirmation that you are in fact paying that, then you obviously should get credit for that. And so what I'll do, Mr. Magnuson, is if he provides that to you, you can contact our office, and then we will, or maybe this way, maybe it'd be better if it might be easier if you just have it recalculated at that point, if he provides you with that confirmation that he's paying it.
I'll do that, Your Honor, once I receive that. Mr. Frazier, you have our address and everything to send that to?
No, I have no.
We'll go from there.
Okay.
All right.
Thank you. Court will end this hearing at 10:46 a.m. You're free to go. The plaintiff has filed a motion to show cause in this particular matter. The defendant has not appeared. It is now 10:48. The matter was scheduled for 10:30. a.m. And the defendant has further not pled or filed any pleadings in this matter as well. Court did note, Ms. McNally, that you had not filed a proof of service, but when you were being checked in, you confirmed that you did in fact serve the defendant by mail. Is that correct?
Correct.
Okay, you're going to need to file a proof of service with the clerk's office
Okay.
in this matter. What happens, the court will grant your requested relief by default as the defendant has not appeared and has in fact not pled. Court will note that you said that the sum of $3,155.67 was owed on the Virginia townhouse. Oh, I'm sorry, that was on the debts.
Yes.
The townhouse was $1,583.84, bringing the total to $4,739.51. The court will grant you a judgment against the defendant in that amount. Okay. That way, once you have the judgment, and you'll then be able to proceed for collection on that judgment.
Okay, great.
Okay, you're going to have to prepare an order granting your motion and providing you with a judgment in that amount. Okay.
Okay.
And you can submit it. You can submit it under a 7-day notice of entry, meaning you can submit it within 7 days of today's date. You don't have to have a hearing on it. If you miss it and don't file it till after the 7 days, you'll have to do a motion for entry of that judgment. At that particular point, you're going to have to serve him with it, with a proof of service filed with the court as well. Okay. Okay.
Thank you.
Thank you. The court will in this matter attend its motion to terminate the personal protective order previously entered in this particular case. So what I'm going to do is have both of you raise your right hands. We'll have you sworn in, and we'll take some testimony and we'll proceed. Ms. Morrow, as it's your petition, you can proceed and tell me what you would like me to be aware of.
So I guess I'll start.
Not you, sir. I said Miss Morrow.
Sorry.
Do you want me to start on the date of the incident, the most recent one listed on the
You can just tell me, you filed a petition, so tell me why the court should terminate the PPO.
Okay. So I had filed for divorce, or I asked my husband for a divorce, and because I'd asked him to go get mental help for a while, he declined. Instead, he chose to entertain other women. So then I therefore decided I wanted to get divorced after going through with it and not taking back his efforts to stay together. He has increasingly become more irritated and more violent with me. On the particular night that the cops got called, which brought on this PPO, I had came home from going out with my one friend, Marissa. I noticed his brother's truck was in the driveway with him and his wife were at my home, which we had particularly not had a good relationship in the past.
Okay, ma'am, I just need the salient points. I don't need all this extraneous testimony. I do have another hearing, so get to the point as to what happened and what didn't happen.
I came into our home. Our children were in the living room. I told them hi and that I wanted to go to bed. So I was telling them good night. I was trying to go upstairs in our family home. Our pantry is right next to our upstairs bedroom. Mason followed me into the kitchen, cornered me in our pantry, kind of shoved me up against the wall, was trying to take my phone forcefully out of my hands. I had asked him, I said, Mason, please stop, please stop, please stop. At this point, Travis, which was his brother, his wife, Brooke, and the children had left the home and went out to the garage before anything had escalated. Mason chose not to let go of my phone. I did fight back in my own self-defense because I wanted him off of me, and there was no reason for him to take my cell phone. My only reason or way to contact somebody to get help. And after I had fought back and pushed him off of me, he then decided to call the police to try to say that I assaulted him.
Okay. What else?
After that, he called the police, and then the dispatcher had said that we needed to separate. So I chose to go outside. I thought he was going to stay in. He then followed me outdoors. Then I was asking, I kept repeating myself. I said, Mason, please leave me alone. Mason, please leave me alone. And I repeated it 3-4 different times. He wouldn't leave me alone. I chose to stand at the end of the driveway. The police got there. They separated Mason and I. They got both sides of our story. Can you still hear me? That blacked out for a second.
Yep, we can hear you.
I had told the police officer from my point of view what had happened that night. Mason tried saying or whatever that I was heavily drinking. I willfully agreed to do a breathalyzer test where I had blew well under the legal limit. They then told me that I needed to find a safe place to stay.
So then I decided to leave and go to my sister Shemaine's house. But upon trying to leave my house, Mason did even try to follow me back to my car that night. And the police officer had to tell him to leave me alone and stop following me. So he had witnessed like some of his behavior that night. Then I got in my car and I left and I went to my sister's.
Okay. Okay, anything else that you have, ma'am?
I mean, I guess just what I had wrote in the PPO, unless you want me to elaborate more on that, in my motion.
No, I don't. I'm just saying, whatever you want me to be aware of, this is your opportunity to tell me.
Okay. Mason, we had met, I believe it was April 29th, after he had put the PPO in place and filed it against me. We had met April 29th to exchange children at the Burlington Fire Hall. And he had then asked me to come back to the house and to have sex with him. And I just thought, he had put the PPO against me. If you truly felt that I was that dangerous and could harm your well-being, why are you still trying to talk to me? Why are you inviting me back to the house? Why are you still wanting me to perform various acts for you? I just don't understand.
Okay. Anything else?
I don't think so.
Okay. Sir, is there anything that you would like me to be aware of in deciding this motion?
No, not in particular. I don't really see a need in having the PPO against her anymore, because without me being around and when she's with the kids, I would like her to be able to protect the kids. I believe she can't have a weapon. If she has a PPO against her, I don't believe she can have a gun. Is that correct?
That is correct.
And I think the situation has calmed down enough to where both of us are, we're I think fine, and I don't see it being a bad thing for it to be removed.
Okay, so you're agreeable to terminate the personal protective order, correct?
Yes, sir.
Okay, you understand at any point, should you just need one in the future, you could file a petition at that point and acquire one. You understand that?
Okay. Yes, sir.
Are you agreeing to terminate this? Are you doing that freely and voluntarily, sir?
Yes, I am.
Has anybody threatened you, coerced you, used any undue influence, promises or pressure to get you to terminate this personal protective order?
No, sir.
Okay. The court, therefore, based upon the statements and the testimony of the petitioner in this matter, the court will agree to terminate the personal protective order. I will tell you, Ms. Morrow, just so you know, it's going to take a few days for this paperwork all to go through the process. So if in fact some incident happened, let's say tonight or tomorrow, the police might come out and say, oh, there's a personal protective order still in place. So we have to get the orders. We got to remove it from lien. There's a lot of things we're going to do, but we will pursue that and get that done. Okay.
Okay.
The court will end this matter at 11:05 a.m. You're free to go. Have a good day.